Here we are at the near epicenter of the coronavirus outbreak in Florida. We are 20 miles north of the Sarasota area, 20 miles west of the Hillsborough area. We are right in the epicenter of the coronavirus in Florida. So it's certainly apropos that we're here today to talk about medical issues and healthcare issues. Now, as we all know, this is an issue of crisis where preparedness is something that makes all the difference. Our governor, no less than 6 or 8 hours ago, just announced a medical crisis emergency here in the state of Florida. So listen to this presentation, understand what we're talking about, and take the steps necessary to ensure that you have properly prepared your healthcare and medical issues. I'm Thom Cox. I'm with the law office of Cox and Sanchez, Rants, informational attorney, and we're here to talk about healthcare and medical issues and what you can do to plan and strategize so that you and your family can be properly prepared for these issues. Now, as you may recall from our presentation and discussion last week, the number one issue concerning seniors is the rising cost of healthcare and the financial burden that it puts on the family. In addition, these concerns are not only who is going to make our healthcare decisions for us, how are we going to pay the cost of it, and what tools, steps, and documents are we going to utilize to be able to handle both the financial and the medical decision part. And that's what we're here to discuss today. We're typically dealing with three types of instruments. Number one is a durable power of attorney. Number two is a healthcare surrogate. And number three is a living will. Each one of these instruments serves a specific and useful purpose in having a global preparedness for healthcare or medical issues. So let's jump in and talk about each instrument and how the documents work and what they're used for. First, a durable power of attorney. Now, what is a durable power of attorney and how does it differ from other powers of attorney? It's an instrument where you, as the principal, grant to a third party, your agent, if you will, certain authorities and powers to make decisions on your behalf. Now, you really need to be careful about powers of attorney because, again, you're giving a third party the right to make decisions for you. Yes, you can revoke it. Yes, you can change or modify as you go on, but you have to be careful. It has to be provided with someone who you have great respect and belief that they're going to carry forward with your wishes. You are bound by the acts of your agent. If your agent does something, you're going to be stuck with the decision that they made. It may be a pain in the rear to try to turn back or modify that decision, but you are bound by the decisions. Now, you can put certain restrictions, and that's what we do. We provide certain restrictions within our power of attorney documents that not only gives your agent the power and authority to do what's necessary to help you in your decision making, but it limits their ability to transfer assets to themselves, to be able to convert assets, to be able to do a new will for you, transfer or modify beneficiaries on a life insurance policy, or any way usurp the authority for their own personal benefit. Next, powers of attorney. There's a whole lot of different powers and authority, but the three main powers of attorney is a general power of attorney. Now, this is what was typically popular 20, 30 years ago. It's a general grant of authority. I, John Jones, give Fred Smith authority and power to take any act or step necessary in furtherance of a certain goal or task. And, typically it was a one or two paragraph, a small page grant of authority. Now, those are really not preferred these days. There's a lot more scrutiny involved in carrying forth or preparing these type of documents because you don't want to give a large grant of authority. You may provide specific issues, and that's the next one, a specific power of attorney. That's to perform a certain act. I specifically suggest or grant John Jones the ability to be able to handle this real estate transaction for me, or to be able to handle this task for me. With a power of attorney, it provides great ability for you to delegate authority to perform a task that you're either unable or geographically inconvenient for you to take care of. If you're traveling out of the country, if you're in the hospital for a medical procedure, you're giving someone the authority to handle the affairs on your behalf. The third type of power of attorney we typically see is something called a durable power of attorney. And that's really what we're going to concentrate on today, because a durable power of attorney has specific utilization within the medical arena, which we think is the primary useful document, the primary useful power of attorney in these type of situations. So let's talk a little bit more specifics about that. Now, again, a general power of attorney, it grants a wide authority to handle things. To handle taxes, pay bills, borrow money, handle banking, engage in lawsuits, engage in negotiations. That's a general power of attorney. And, a general power is useful in some circumstance because you cannot always determine what steps or acts the agent needs to prepare for or be involved in on your behalf. So in your power of attorney documents, there should be a general large grant of power, but it also should detail and specify the powers being granted. A specific power of attorney is a real narrow area of a transfer of authority. So again, like we talked about, it may allow a person to handle, for instance, prepare your tax returns, or engage in negotiations, or handle a real estate transaction for you. Specific powers of attorney are typically designed for a single type transactional event. That's why the majority of these powers of attorney are time sensitive and time limited. So for instance, if you're selling your house up in Michigan, and you want your cousin to be able to handle the transaction for you because he lives in Michigan, you could give that cousin a specific power of attorney, which would name the property, the address, the duties, and tasks that he's going to handle on your behalf, and it's going to provide that it's good for a certain period of time. So when doing title work or handling something specific with regard to a real estate or other transaction, a specific power of attorney is a great instrument to utilize. Now, a durable power of attorney, let's talk about what it does, what the differences are. But a durable power of attorney gives you the best of both worlds. It gives you the ability to utilize the general grant of a power of attorney. We give wide legal authority to handle affairs on your behalf. You can also limit the scope with a specific power of attorney. But the real distinction and the reason we like durable powers of attorney is that with a standard power of attorney, be it specific or a general, if the principal, which would be me or the person granting the authority to the other party, if the principal should be deemed incompetent or incapacitated, the authority given to the agent ceases. Let's be real. When do you really need to use the power of attorney? When you're unable to do it yourself. I mean, that's what a power of attorney is for. It's not merely for the convenience of you traveling or someone doing the duty for your behalf. The real beauty of a power of attorney is if you're unable to do it yourself because of mental or other incapacity, that your agent can perform the duties for you. Now, what does durable mean? The authority granted in a general or specific ends the moment you become incapacitated, or it ends in the event a third party, whether it be a family or court, initiates an act for guardianship. or determination of competency. Once one of those acts occurs, the power of attorney normally ends. But with durable, there's a language within the document that specifically says, hey, if I have a mental incapacity, if I have a stroke, a heart attack, if I have dementia, Alzheimer's, then the power of authority granted to my agent continues. So that is when you really need to utilize, and that's why the power of attorney should be used in the first place, to ensure that your affairs can continue. Utilizing a durable power of attorney really saves you time and money and court involvement. Because if you don't have a durable power of attorney in place and you become incapacitated, if an act or something needs to be done, whether it's sell a house, whether it's go into a bank account to get money for a medical procedure, guess what? You can't get to it. The only way to do that would be to file a petition with the court to determine capacity and appoint a guardian. So what happens? Petition is filed, doctors are appointed, the court makes the decisions, you pay filing fees. 2 months down the line, finally someone is appointed in that capacity, and someone has authority to make decisions for you, not only financially, but physically. Be able to make the decisions with regard to where you should live, what you should do. That's what a guardianship does. You're putting the court in control of your life. Wherein, if you have a durable power of attorney, guess what? You have made the decision. Who you trust, who you believe can make those decisions for you, what your wishes are, and it's done timely, it's done efficiently, and it's done confidentially. Next. Now, the durable power of attorney role in healthcare, in addition to the ensuring that a party can handle your financial or other affairs without court involvement, is that if there's any decisions to be made with regard to negotiations, medical billings and expenses, let's say you need to go to a rehab facility or a nursing facility, your agent under the durable power of attorney would be the one signing the financial documents on your behalf, entering into the negotiations, or being involved in the aspect of assisting the medical decision provider in making decisions. They will work hand in hand with the individual who will make the medical decisions for you, and that is your healthcare surrogate. So let's take a look at the next slide and let's talk about that. Does the agent under the durable power of attorney need to be the same person as the healthcare surrogate? Absolutely not. In fact, it might work better not having the same individual in that capacity. You typically have to take a look at the attributes of each hat the individual is going to wear. An individual under the durable power of attorney, you want someone who is obviously trustworthy, someone has the ability to understand the implications of what they're signing, someone understands and has some financial savvy involved because they're going to be involved with your financial affairs. And with a healthcare surrogate, you want someone who is empathetic, who understands maybe healthcare or medicine, or someone who, in essence, understands what your position and decision is and can carry out your healthcare decision as you have directed them to. Now, could this be the same person? Absolutely. If your son or daughter wants to fill that role or capacity and you feel they're capable of making those decisions or helping out, then they can absolutely fill the same role. But again, a healthcare surrogate makes medical decisions for you. Durable power of attorney makes all other decisions other than the healthcare decisions. Now, let's spend the time and let me tell you a little story here. So let me take you back to December of 1963. And let's talk about a young lady who is someone that we will get to know. You understand? What you need? I'm sorry, Jim.
I was trying to find your Terry
I don't need that.
Okay.
So, in December in 1963, a young lady was born to a nice family up in the Philadelphia area. She lived a pretty normal lifestyle, engaging, exciting. She had a little issue with regard to weight gain, and of course, we know all teenagers, all young adults, especially females, worry about issues of their health and their medical issues. She got to about 250 pounds in high school. Well, this young lady met a young man up there, went to junior college, ended up getting married. Well, they moved down here to Florida, and she was able to get control of her health and her diet. And in that capacity, she became, she lost over 100 pounds. She got down to about 150, 145 pounds, was involved in a lot of work and other activities, was a very happy, healthy, young married woman. Unfortunately, in 1990, at the age of 26 or 27, she suffered a cardiac arrest and had a heart attack. 26, 27-year-old woman. They determined that her medical condition was caused by a lack of potassium and electrolyte imbalance in the system. Her way of dieting and keeping her weight lost was drinking lots and lots of iced tea. Unfortunately, this young lady went into cardiac arrest for several minutes. She was revived, taken to the hospital, and she was hospitalized for another 24 years. The young lady that we're talking about is Terry Schiavo. You probably have heard the name. This is a case, again, that drew national attention. It's a case that ended up in court for many, many years. There were 22 or 3 different lawsuits filed in this area. There were 5 different appeals. This case was analyzed and heard and went all the way up to the federal Supreme Court, who decided not to hear issues through a writ of certiorari. And actually, George W. Bush actually commented, and there were lots of laws and groups that debated the issues with regard to the right to life and to live. Terry Schiavo was deemed clinically brain dead after 2.5, 3 years worth of attempts to revive her. Her husband said, "Hey, this is not the way my wife would want to live." He asked the court to be able to shut off her life support system, to stop nutrition and hydration or food and water to allow her to die naturally. Her parents, being the loving, caring parents that they were, they did not want to believe that she was gone. So lawsuits, litigation, and lots of vigilance on their behalf and other groups ensued. And again, she finally was removed from life support after 20, 25 years. Millions of dollars worth of care. Everyone wanted this woman to have the best possible life. But the decision was not really the husband's. It was not really the parents'. The decision was her decision to make. He testified in court that they'd had a discussion and that she told him what she wanted, and she did not want to be artificially kept alive if it wasn't a life worth living. Those are personal decisions, and those are things that you need to make, or you end up in litigation like this when there's a difference of opinion. So let's talk about what this situation or how this situation can be resolved. It's called a living will. And a living will is your expression of your desire to be treated in the event you have a end of state condition, are terminally ill, in a persistent vegetative state, and death is imminent. This declaration simply says, hey, I either do or do not want food or water withheld in the event I have one of these conditions. In addition to the declaration that you have made, the law requires that two physicians must also determine that there is no medical treatment that will help you recover, and there's no possibility of recovery. So you have to be in a persistent vegetative state. If a living will had been in place, the court would have certainly easily ruled whatever her decision was, that's what the court would file. Now, the other issue is, okay, let's say you have a living will. How are you going to enforce your living will? And you do that through a healthcare surrogate. This is an individual, as we discussed before today, who you have deemed competent and capable of carrying out your healthcare wishes. And again, it's your wish. This individual is going to make medical decisions on your behalf if you're unable to make the decisions for you. Their job is to be your advocate. Remember I said previously, hey, this needs to be a strong person. They need to carry forth what your wishes is. They may not agree with how you have structured your living will, but their job is to put your hat on and be you, to be your advocate. If you say, look, I want no hydration or food or water in the event I'm in a persistent vegetative state, it's their job as your healthcare surrogate to make those hard decisions for you, to talk to the doctors, to say, look, here is this person's wishes. Please allow them the dignity to be able to continue their life or not continue their life according to the healthcare surrogate. This eliminates the need for the court to establish a guardianship of the person. Again, if you don't have one of these instruments and no one can make medical decisions for you, guess what? The court makes it for you. They appoint a third party who doesn't know you from Adam, who doesn't understand what your desires, wishes, life, history, anything. And this person could be making healthcare or medical decisions for you. So let's continue on. Healthcare surrogate directive, it is in force and effect as long as you allow it to be. If you want to change it, you absolutely can change the healthcare surrogate, but it only arises in the event you are unable to make your own decisions. If you're under anesthesia, if you're in a coma, if you're in any type of medical condition where you mentally do not understand the extent of your condition and how to properly plan for your medical well-being. It could be Alzheimer's, it could be other condition, but this power is only initiated or springs into effect once you're unable to make your own medical decision. Now, remember, this is the medical decisions. All other decisions are as the durable power of attorney. So as you can see, these two powers work together to be able to give you the full opportunity to have your life lived as you deem appropriate. Now, let's clear up a couple things. Let's talk about some issues that I hear a lot from folks. What is a living will and what is a DNR? And are they the same thing? I get clients calling all the time and says, hey, did you do a DNR for us? The answer is no, I don't do a DNR. A DNR is a do not resuscitate order. And the differences are a DNR is usually prepared by your medical providers, by the doctor or by the hospital. We don't prepare them as attorneys. It's only issued by a physician after the patient is already diagnosed as medically unsound either terminally ill or in a medical condition that is digressive. And this is supposed to be honored by paramedics. You'll usually see these documents bright yellow or bright orange, and most folks are instructed by their doctors. And by the way, paramedics are instructed to adhere to this. Take a look at the refrigerator. Believe it or not, the current administrative protocol is if you have a DNR, you put it with a magnet on your refrigerator or some place that is readily observable. That's why it's bright in color, and that's why it needs to be put someplace that is readily observed by the medical personnel. A living will, we've talked about what a living will does. A living will is your declaration as to what your position would be in the event, again, persistent vegetative state, end of life condition, terminal condition, and it addresses different issues than the DNR order. So those are the distinctions between the two. It addresses end of life planning and medical decisions, but does not address do not resuscitate me in the event my heart stops or fails. Any further questions? Please feel free to contact us. Happy to work with you today. And again, it's an unusual day. Here we are talking about medical issues, medical decisions, healthcare decisions, when we're under a current emergency medical order here in the state of Florida. So this just shows that you don't know what's going to happen. Everyone should be prepared. Everyone should have these documents for themselves and their loved ones. Great talking with you today, and we'll certainly see you next week.